Before we begin, remember that this video is for educational purposes only and isn't legal advice. Case summaries are meant to support your study, not replace reading the full case. If you're studying law, this case summary is one worth knowing cold. You sent an acceptance in the mail, but the other party says they never got it. Are you actually in a contract? Today, we're breaking down the Postal Rule using real-world cases so you can protect your business interests and avoid expensive legal disputes over timing. Let's start with the case that started it all. This is the foundation of how we may help with mail in contract law. Back in 1818, a seller offered to sell wool but send the offer to the wrong address, causing a delay. By the time the buyer's acceptance arrived, the seller had already sold the wool to someone else. This created a massive problem regarding exactly when a contract becomes official. The court decided that the contract was formed the moment the buyer put the letter in the mailbox, not when the seller received it. This was a revolutionary shift in legal thinking. It means you can be bound to a contract before you even know the other person has said yes. The reasoning here was about business efficiency. If we waited for the letter to arrive, the buyer would then have to wait for a confirmation that the seller got the letter, creating an endless loop of, "Did you get my letter?" The law chose a definitive cutoff point to keep commerce moving. Just because you use the mail doesn't mean the rule always applies. Henporn v. Fraser added a layer of common sense to the rule. In Henporn v. Fraser, the parties lived in different towns. The court ruled that using the post was reasonable because of the physical distance between them. If you're standing in the same room, you can't just mail a letter later and claim the postal rule applies. A critical misunderstanding is that the postal rule only applies to acceptance. If you want to take back an offer, that revocation is only effective when it's actually received. This creates a race where the acceptance might win, even if you sent a cancellation first. To avoid these timing traps, always specify the required method of communication in your offer. If you don't want the postal rule to apply, you may want to explicitly state that the acceptance is only valid once it reaches your desk. This prevents being bound by a letter lost in the mail. Quick reminder, this is a study summary, not legal advice. Always read the full judgment for complete context and nuance. What happens if the letter never arrives? Household fire insurance for grant gives us the answer, and it's a warning for every business owner. In this case, a man applied for shares in a company. The company posted the acceptance, but it never arrived. When the company went bankrupt, they sued him for the unpaid share price. He argued there was no contract because he never got the letter. The court held that the post office acts as a common agent for both parties. Once the letter is handed to the agent, it's as good as delivered to the other party. This means you can be legally responsible for a contract you don't even know exists. This case highlights why you should never rely on standard mail for high-value agreements. People often overpay for legal battles because they didn't use tracked delivery or digital confirmation. The risk of loss falls on the person who could have specified a safer communication method. Anyone stuck with the postal rule, Holwell Securities v. Hughes, shows us exactly how to protect ourselves from these default legal principles. In this case, the offer required notice in writing to the offerer. The court ruled that this specific phrasing meant the postal rule didn't apply. Notice implies that the information may want to actually reach the person for it to count. If your contract says acceptance is effective upon receipt, you have successfully bypassed the postal rule. This is a safe first check for any business agreement. It ensures you're never surprised by a contract that started 3 days ago while a letter was in a truck. Many people use vague language like, "Let me know by Friday." This doesn't necessarily exclude the postal rule. If they mail it Thursday and you get it Monday, you might still be in a contract. Use precise language like, "May want to reach my office" to be safe. We don't use the post as much today, but these rules still influence how we handle email and instant messaging. In Enterez v. Miles Far East Corp., the court decided that for instantaneous communication like telex and later email, the postal rule doesn't apply. The acceptance may want to be received to be effective. This is because the sender usually knows immediately if a transmission failed. While email is generally considered instantaneous, What happens if it goes to a spam folder or arrives after business hours? Courts generally look at when it was available to be read. This is why automated read receipts or received acknowledgements are vital for your records. Review your standard terms and conditions. Ensure they specify that no contract is formed until you send a formal confirmation of receipt. This puts the power back in your hands and prevents accidental contracts from automated systems. Always keep a paper trail. If you may want to use mail, get a certificate of posting. If using digital methods, save the sent metadata. In a dispute, the person with the most concrete evidence of timing usually wins the argument over costs. If you're dealing with a contract worth more than a few $1,000s or one with long-term liabilities, don't guess. A qualified legal professional can review your offer and acceptance clauses to ensure you aren't vulnerable to old-fashioned rules like the Postal Rule. Before you sign or send, ask, how is acceptance defined? Is there a receipt requirement? What is the backup plan if communication fails? Answering these 3 questions can save you months of litigation and thousands in legal fees. That's the practical version of the Postal Rule. The big idea is to understand that the law has default settings that might not favor you. By being specific about how and when an agreement is reached, you avoid the lost-in-the-mail nightmare and keep your business protected. If this helps you understand the risks of contract timing, like and subscribe to Law Conquer for more practical legal education breakdowns. See you in the next one. Remember, this is a summary for study purposes. Always read the full case. Thanks for watching. Remember, this is educational only. Read the full case and consult your course materials. Subscribe for more case summaries.